I'd ask everyone at this time to please rise to salute our nation's flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This is a special meeting of the governing body of Borough of Bloomingdale, Tuesday, August 9th. It's an official meeting, July 22nd. It was advertised, public notification sent to all local news media, faxed as well, and posted here at Borough Hall. Item 5, I'm sorry, roll call, please. Yes.
Present.
Here.
Here.
Present.
He should be here momentarily. Also with us, Jay McCarthy, our Borough Clerk, and Borough Attorney Fred Semrau. You don't have an early public comment on that? Okay. Right, for the public hearing. Okay. The first order of business is special business item number 5. What I will do, because there's no early public comment on the agenda, but there's obviously public comment in the ordinance hearing. After the ordinance hearing, before we get to B and C, if anyone wishes to speak to an agenda item, because that's what our early public comment is reserved for, we will do that. And then upon conclusion of item C, we'll have a late public comment, as we always do. Okay, Jane, just to give everyone the opportunity to speak to an agenda item before it's discussed or actions taken. Okay, second and final reading and public hearing on ordinance 2016 AH1 overlay zone. Public notice statement, please.
Yes, Mr. Mayor, this ordinance was posted in the municipal building, published in the Herald News. Copies available to the public, said a motion may be made that be read by the clerk.
And who makes that motion?
So moved.
Second.
All in favor?
Aye.
That would be an ordinance of the Borough of Bloomingdale, County of Passaic, State of New Jersey, establishing section 92-61.1, the Borough Code known as the AH1 Affordable Housing Overlay Zone.
Thank you. I now need a motion to open the public hearing.
So moved.
Second?
All in favor?
Aye.
Okay. Any resident, anyone here wishing to speak to 2016, please come up, address the chair, state your name and address for the record. I will ask, everyone obviously will have the opportunity to speak, but I will state that anyone who's previously spoken, anything you've stated is on the public record, and was heard by the governing body. So I just ask you, try not to repeat ourselves if we can. Yes.
Linda Huntley, 86 Van Dam. After the COA meeting in Patterson in July, Fred approached our attorney and said that wanted to know if there's any way that this conflict could be resolved. Our attorney at that point said that he really didn't think so, and we didn't think so either. But then at the last meeting, when you had mentioned to Ross about saving certain portions of Federal Hill, well, then I thought maybe we could do something. So I contacted the attorney and told him that we would be willing to negotiate if we could save phases 1, 2, and 3 in exchange for 10 acres on the bicoastal for a haul road. In other words, we were going to protect all the property that is currently under the conservation easement. Our attorney brought this to my attorney brought this to Fred, and I'm assuming I brought it to you and the council. Also, during the discussion, he had mentioned that we didn't feel that the ordinance should be passed because if it is voted and passed on, then we have to file suit because we have a certain amount of days within which that we have to file our suit. But what I've heard back from my attorney is that this is not going to be taken care of until maybe sometime in September, which is beyond the 45-day period of time which we need to file suit. So from my viewpoint, meaning me, the Committee to Save Federal Hill, and all of its members, which is numerous, it tells me that you're really not going to negotiate with us. And I need to know if there's going to be negotiations, and if there are, why are you going to be voting on this ordinance this evening?
Well, let me just, before I give Fred the floor, Fred did advise in the memo form the governing body of exactly what you just said, but the governing body has not met, to formally discuss that issue. But I will say, and I've said it a few times on the public record, that it would absolutely be the intention of this governing body to look at, because of the concerns of setbacks, particularly along Van Dam Ave, to consider bicoastal, some portion of bicoastal, to preserve as much as possible, if not all of it, on the 140 remaining acres of Mere. So that is absolutely the intention of the governing body going forward. And that's really all at this point I could say. Time frame, your question was, why would we move on the ordinance? Well, again, I believe to get Green Acres to consider doing so, okay, the ordinance on the books may give leverage to actually allow that to happen, to allow land to be traded.
Okay, but then I understand that, but we're going to be filing suit. And if we file suit and we win, then you've got nothing to bargain with at all.
Well, again, that's your prerogative. You have 45 days
Oh, I
to
know,
file suit
but-
from the adoption of the ordinance, and you could file immediately, and I would hope that we could come to an agreement with you and your litigation, prior to having to go very far in that litigation. That would be the intent and goal of the governing body. But if not, then we proceed as we plan to, with trying to preserve as much of Mere as we can with the bicoastal piece. And if you choose to continue litigation, then that's entirely your call.
Okay?
Okay? Let's hope it doesn't have to go that way. Before you go, I'll just see if Fred has to add anything, wants to add anything to that.
Yeah, I think that the concept in itself that was discussed at the last meeting is something that has a very good result, for the entire borough. And so I think, to what the mayor said, it's something that, he's asked me to start to work on to see if we can bring back basically a contract for that property. But I have to bring it back to the governing body, of course, for their consideration and see where it goes. I mean, but from a standpoint of what's before the governing body tonight, it's one that's, that ordinance is on a standalone, and then I think whatever happens in September, I've been asked to try to really move it along. I told your attorney that. We're going to really try to move that along because that's in everybody's interest. And it would be great to see if all or a portion of the property that borders Van Dam doesn't have a, for discussion now, this, setback or something to that effect, but has a Green Acres, restriction on it, because then everyone knows that's for good. That should really be.
Then it would be, I would hope when this negotiations, if they do occur, that it would be that we were going to be saving Federal Hill, the area that is currently, in my opinion, and in my attorney's opinion, under conservation easement, as well as Green Acres, because this way it'll prevent any future governing body from doing anything. Because unfortunately, seeing what's happening here, when I was on the governing body, we thought we preserved it. And now all of a sudden, it's not. So I don't have confidence in subsequent governing bodies, unfortunately, because of what has happened here. So that's why
But
we
also,
want to make sure
your
that it's-
attorney thought, and I agree with him, that it would be a real positive outcome.
Oh, I think it
That's
would
the
be
bottom
too.
line for everybody. I think it would just be very positive if that were to occur, But there's another party involved, and we're going to have to, negotiate and reach out.
Right.
Okay.
Thank you. Anyone else, please? Okay, seeing no one, I need a motion to, I'm sorry. Was anyone else? Please step up to the microphone.
Last call. My name is Elliot Ruga. I'm the Policy Director for the New Jersey Highlands Coalition, and I'd like to bring to your attention a document that is very much a factor in what you're doing tonight with your ordinance. I mean, there are several items that come together to allow this development to occur. One of them is the document titled "The Summary of Bloomingdale Borough's Proposed Affordable Housing Strategy," issued on January 29th, 2016, and there are some gross misrepresentations in here I'd like to call to your attention. On page 2 in the third paragraph, it says, with talking about Highlands Council jurisdiction, it says, with respect to the planning area portion of the borough, although Bloomingdale has not been formally deemed compliant by the Highlands Council, a petition was submitted by Bloomingdale in 2011. Pursuant to many state and local regulations, the borough is effectively compliant with the goals and objectives of the Highlands Council. I think that is quite a stretch of the imagination, because I believe this body formally opted out of planning area conformance so that this zoning ordinance would not be scrutinized by the Highlands Council. And on the last page of this report, it shows, it's sort of a checklist of certain things that have to be considered before the mere tract can be considered appropriate for affordable housing. It says, it's asked if this is approvable on a local or state level. You say yes. I believe that's no, and I'll explain why. And that it is developable because it has sufficient water, it has sufficient sewer, and an amendment to the area-wide water quality management plan is would be approvable. In fact, this sub-watershed that this portion of Bloomingdale lies within is in a deficit. There isn't, it's identified by the Highlands Council as in a deficit situation. And there's an Executive Order 114 that was signed in 2008. And executive orders are in effect unless repealed. This has not been repealed. And it states the following: that the Department of Environmental Protection shall take appropriate action to ensure that no water allocation permit is issued for any development project located in the protection zone, the conservation zone, or the environmentally constrained subzones. This is in the protection zone. The entire mere tract is in the protection zone, as delineated in the Highlands Plan within a Huck 14 sub-watershed that is in or anticipated to be in a deficit of net water availability as identified by the Highlands Plan, until such a time that a municipal water use and conservation management plan consistent with the policies in the Highlands Plan has been approved by the Highlands Council and has been fully implemented. This site is in a water deficit, it is in the protection zone, and it cannot be approved by DEP. And this is regardless whether you're in conformance or not in the planning area. This is for all Highlands municipalities. Secondly, the DEP shall take appropriate action to ensure that no approval is given to any portion of a water quality management plan amendment in the protection zone, the conservation zone, or the environmentally constrained subzones as delineated in the Highlands Plan within a Huck 14 sub-watershed that is in or anticipated to be in deficit of net water availability as identified by the Highlands Plan, unless approval is conditioned on a municipal water use and conservation management plan consistent with the policies in the Highlands Plan having been approved by the Highlands Council and having been fully implemented. So I would argue that this is not something that can be approved by the state at this time, and I just thought it was important to point this out to you. Thank you very much.
The one question I have for you is,
Yes.
what can't be approved by the state? Water sewer permits for the 32-acre court-ordered housing development?
Yes?
Okay. I just recall the court order referencing all of what you just said, and
I think it talked about the Highlands Act, but the court was basically of the mindset that, well, there's just, this is a last resort, and I'm not going to essentially let that stand in its way. But keep in mind, everything that's before the governing body tonight, it's not a development application.
Right.
And it's very true that if the state steps in any aspect, to Elliot's point, that's for a different day, and some of those that executive order I'm familiar with.
Okay.
Just to your point, if as Mr. Shamrock just said, if the state stepped in, let's say there's a developer, applying for those applications that you just said can't be done, and you're right. Remember, the ordinance does not allow quarry expansion unless the affordable housing is achieved. So, there would be no quarry expansion unless it was actually able to be done. So that's how the ordinance reads. Right?
Right. Can't have one without the other.
Okay.
Can't have it both ways either, And
We know there is no COA right now, but there are adopted regulations that guide COA, and those regulations are still in effect, and they probably would be considered by a judge, and that they do not allow affordable housing developments, inclusionary developments, in environmentally sensitive areas, planning area 5. And it was this governing body that appealed to the State Planning Commission and had it redesignated from suburban planning area 2 to planning area 5 with respect to the environmental sensitivity of this area.
First, it's not this governing body in 2011, not by any stretch.
It's the governing body
Well, I'm just saying, you
of
said
the
this.
Borough of Bloomingdale.
I'm just correcting the record. You said this governing body. It was not this governing body.
I meant the one under that
Okay,
emblem.
that's just clarifying the point. But the court order was prior to that, just for the record. The court order approving the housing development. That has been,
I think the court order was after.
no, prior to the governing body in 2011 taking action to declare what Elliot's referring to.
To declare it as a PA, to get the designation of a PA5? I thought the PA5 was even,
Well, that was years ago.
Years ago,
But he
yeah.
referenced 2011.
But when the
Highlands
a
Council.
site-specific plan comes forward, this could be grounds to object.
But again, it's a court order, and if that is the case, then
and there's already been an approval on the site,
Right.
not only the court order, with this designation. I mean,
After the Highlands.
just to, to reference that. But I don't disagree with what you're saying as far as what that executive order says.
Yeah, I doubt there was someone representing the natural resources at the declaratory judgment hearing.
For the affordable housing, you mean?
Yes.
Well, but throughout the process, there were numerous agencies copied as part of on the communications and noticed, for the hearings that they were.
Right.
okay, but thank you very much. Yeah.
I had a question about, not necessarily for you, but probably more for Fred, which is that a couple of things that you referenced stated basically until the Highlands Council says it can, essentially, but the Highlands Council is basically in limbo now. So how does that affect?
No, the COA is in limbo,
Yeah,
not
COA,
Highlands Council.
Well, I thought part of that was because the Highlands Council
No,
wasn't
they
really
have-
doing anything.
They have their full plan, their master
But
plan.
I thought they weren't really meeting anymore.
Their meeting.
That's
No, they
COA.
do. That's COA.
COA is the one
COA
that
is the
has
one in flux.
essentially
Okay.
been
That's
shut
why the
down.
Superior Courts are handling it now.
Right.
So, thank you, Elliot. Anyone else, please come up, state your name and address for the record. Yes, they're fine.
My name is Tony Granado, and I didn't raise my hand earlier because I'm not a resident, but I am
fine.
a representative of the New Jersey Sierra Club. And we've been here before, but I did want to reinstate our opposition to this ordinance for the council tonight. So we believe that the town council needs to vote this down because this is one of the most environmentally sensitive sites in the Highlands, and this project would actually ruin the site and remove Federal Hill from the maps of New Jersey. Instead of a historic, environmentally sensitive mountain, this would be one giant flat parking lot. We believe that you should not be expanding a dangerous quarry into such a sensitive area because it will disturb the high-quality C1 streams and risk the water supply for too many people. Expanding a quarry onto this site is an environmental disaster. Quarries by nature are heavy industrial mining operations that destroy everything in its path, like streams, aquifers, wetlands, vegetation, animals, and forests. And the Sierra Club was one of the leading organizations, as well as the Highlands Coalition, to pass the Highlands Act and some of the regulations that Elliot discussed. We believe there's no legal justification under the municipal land use law to zone an area that is environmentally sensitive for heavy industrial extractive use. Expanding the quarry zone violates existing municipal zoning and the master plan, as well as the Highlands Regional Master Plan and the state plan. Since this is an affordable housing unit site, quarry expansion could lead to changes in the COA plan, like formerly discussed, with other environmentally sensitive areas getting developed, and that's one of our main concerns. We believe this ordinance would allow irreversible damage to the Highlands and its environment. It looks like this project would only save the Highlands by trucking the mountains all over New Jersey. People have worked for decades to prevent inappropriate development on Federal Hill, so we really don't want this ordinance to move forward. Thank you.
Thank you. Yes.
Good evening. My name is Wilma Fry. I'm Senior Policy Manager for New Jersey Conservation Foundation. I am here tonight to suggest and urge that this council choose a wiser path to affordable housing than the one that is currently being considered. The smart way to do affordable housing is through 100% affordable units, not merely 20% or less, such as is proposed in this development on the Mayor Tract. The number of units, I believe that the Mayor Tract proposal is for 350 units, of which 4/5 of which you don't want. The affordable ones are the ones that are the goal. There are nonprofits that develop 100% affordable developments, as I'm sure some of you have heard, and that is the way to go. It is less stressful on the water supply, on the resources of the municipality, than these, in quote, inclusionary developments. This development was proposed years and years and years ago, way before the Highlands Regional Master Plan, and is somehow this stupid development has survived up until this point. I think it's time for this council to get this stupid development out of the way and pursue an intelligent path to affordable housing in Bloomingdale. There are people who could help you do such a total 100% affordable development. It is not even necessarily entirely in one development. As you probably have heard, in some cases, affordable units for disabled or people with other issues, each bedroom counts as one unit. And I don't think that the judge in this case, the judges, or even the Fair Share Housing Center care how you do your development. They just want a number. So it is not, you don't need to jeopardize this beautiful resource, this important environmental and historic asset that the town has, in order to provide affordable housing. You can do it another way. I'm urging you to not approve this ordinance this evening and to take another look. It will take a little time, but it will take another look at how you propose to do your affordable units. Generally, the people who advocate for affordable housing are very comfortable with and like the 100% affordables. So I am imploring you to please not destroy the residential and natural resource assets of this town and make life miserable for other people who are closer to this quarry arrangement, and postpone this vote, stop this vote, and give another look to a better way to provide your affordable housing. Thank you.
Thank you. Anyone else, please? Yes.
My name is Ross Kushner. I'm here representing the Pequannock River Coalition. I have a letter I'm just going to read into the record. The Pequannock River Coalition has been an active participant in the process that led to this ordinance. We put on record a long list of objections and countless corrections to both the overlay zoning and the documents that support it. It is destructive of the environment, will promote flooding, will cause a huge reduction in local residential property values. Not one of these concerns has ever been addressed. Although every community is free to choose its own path, this should be done honestly and based on factual information. In this case, every report, study, and document produced in support of an expanded quarry has contained misinformation, false assumptions, and in some cases what can only be seen as outright attempts to deceive the public. As examples, the Mere Tract flood study on the borough website was based on a quarry expansion that will be limited to the Phase 3 line in Tilcon's presentation. But the quarry is not limited to that line, therefore the study is meaningless. Yet it remains on the borough website to convince any skeptical residents. The Autel Group report, also on the borough website, used a paired sales analysis to support their opinion that there would be no reduction in property values due to the expanded quarry. However, the analysis showed homes 2,000 feet from a quarry as near to quarry, and homes only 900 feet from a quarry as distant from quarry. In no case was a single home in the study within 300 feet of an active quarry as permitted by your borough ordinance. Due to these serious errors, the study's conclusions are useless. The Redding Associates report, a financial analysis, used as a cornerstone the, quote, fact that the borough would receive a land donation from Tilcon valued at $10 million. This information, according to Mayor Dunleavy, was supplied by him. However, in numerous public statements, the mayor has said there was no agreement for this land donation, and there never will be. The report is another baseless document whose only purpose seems to be to deceive our citizens. Other documents produced, such as the periodic reexamination of the master plan or the modified master plan, were just as flawed. In fact, never in our 20-year history have we seen such misinformation foisted on the public. Not one of these problems was ever questioned or corrected by Bloomingdale officials, as long as they supported the quarry expansion. Only those citizens who spoke against the rezoning have been badgered and ridiculed. At some point, intentionally supplying and broadcasting false information and failing to correct false documents with well-known established errors crosses the line from unethical to criminal. PRC must question the conduct of the planning board, the mayor, and the council in this light. It is our hope that legal means will be effective in overturning any decision to approve this rezoning. The public and the environment deserve that much. Thank you.
Anyone else? Yeah, I have someone up here first. No, you go, sir.
Dan Hawkins, 6 Pearl Street. Despite my best efforts to the contrary notwithstanding, you still have 2 contradictory sections in the ordinance. This is more of a housekeeping. Item G, with respect to access, as to the AH1 overlay zone, there shall be no access provided with respect to the AH1 overlay zone except from the adjoining quarrying operation and site. Any other access to the overlay zone will only be for the purposes of emergencies and permission by the borough. Under I3, the access to the property shall be permitted from an adjoining property so long as the contiguous owner consents to such process and which is approved by the planning board in the form of site plan approval. Which is it? No access or access by permission?
You have a comment on that? I mean, there's no access from any Bloomingdale
Right.
parcel.
And if there is, you need to have the consent of the adjoining.
Item G says, period, end, no access. Item I3 says, if you get the permission of the adjoining property owner, you can have access. So which is it going to be?
No, item G says there should be no access except,
In case of an emergency?
no, except from the adjoining quarry operation and site.
Yeah, but they already own that. They are not an adjoining property owner under item I3.
The point is, the only access that would be permitted would be from that adjoining property owner quarry site.
Right.
And you have to have the approval to do it. It's not as of right, it's a continuation. What item G is saying, the only access is from an adjoining quarry operation, and what I is saying is, that must be with the consent of that adjoining property owner.
I think you're stretching, I think you're inserting, you're making a declaration that is not necessarily, supported by the prima facie statement here. Access to the property shall be permitted from an adjoining property. They are not an adjoining property, all right?
You can't say it shall be permitted without getting the approval of that adjoining property owner. You
Yeah,
can't
but
force
G
that
says you're not going to get any access, period, except from the area of operation. You already have permission. You don't need permission
You
from...
don't necessarily have permission if it's owned by a different property owner.
You have permission, G says you can access the overlay zone from within the existing quarry property, okay? That's what G says. You don't need to file a site plan approval. It's already one site. Why would they need approval in order to create a road or get access from their own property to some place else on their own property?
Because it'd be owned by somebody else.
Item 3 says,
It just keeps going.
the contiguous owner consents to such access. This implies that it's some owner other than Tilcon, because why would Tilcon not consent to access something from within its own property?
Yeah, but you're right. It could be. Right now, they're different owners. The property's in different names.
They're separate lot and blocks.
That's precisely.
Separate owners.
That precisely fits to what you just
Right.
analyzed.
Who is the ultimate majority shareholder for both operations?
I don't know. I believe from all representations that Tilcon has an interest in Finbar, which is the owner of the property.
And if
But
it's
they're two-
51% or anything up over 50%, then
But I
they
think
are in
you
effect
just
the same
answered-
owner.
You just gave a good example as to if it's a different property owner, which in case it is, there has to be consent. We're not going to, we can't order someone to provide that access. And without it, that's up to any prospective property owner that they have to make that arrangement. They can't come to this town and say, I'm landlocked and now I want to have access from some other location, such as Van Dam. Not going to happen. You either get it from the contiguous property owner or you don't have it. So to eliminate that would be to essentially landlock that property, which would not be a good idea. So, and this went through the planning board. There was no comments to the negative to that, and I think you just gave a good example as to why that language is important.
If Finbar is a wholly owned subsidiary of whatever corporation happens to hold ultimate control of Tilcon, all right, Finbar didn't just come up with this money out of the blue. Somebody financed this deal, all right? And if Tilcon is the one, putting up boundary fences and whatnot up on the property now, we can assume that they are probably the controlling property owner. Otherwise, they would need permission from the property owner in order to do that activity. So I think, this is, you're going to bridge too far here. In my view, you're opening the door under I3 for somebody who is not Tilcon or not Finbar to offer their property as an access way, all right? Again, of course, site approval is still required, but, you know, in one case you shut the door, in the other case you open the door. I just think it's a contradiction that doesn't need to be,
Yeah, you've duly noted.
okay?
Yeah, thank you. Anyone else, please? Yes, sir.
Hi, my name's Joseph Carreri. I live on 17 Brant Lane, and I could hear in behalf of me and my neighbor as well. 2 weeks ago, we watched the river come all the way up to our road level. We had town guys there. We had the police driving by, and I have a wife, a 5 and a 2-year-old, and I just don't know how I could look them in the eye after this development happens and say to them that they're safe or that the money that we invested in our house is safe. We recently got a letter from an insurance company that says now we're required to have flood insurance, which before we weren't, which we do have because of where we live, but our block is a quiet dead end. There's families there, kids. We walk our dog there. My kids ride their bike in that road. I'm not sure if we're allowed to ask questions here, but is that going to be an access road to these developments? Is that going to be used for bringing construction material? Because past the animal shelter, that road's looks like it's, you know, being marked up and cleared as part of access there, as well as the house at the end of our block was abandoned for a while, and there was tons of debris growing and things, and somebody recently purchased it, and they cleared all the high grass and did a lot of things. As a result, we've gotten, you know, rodents and animals and things. So as this land gets developed, those animals and stuff like that are also going to push toward our house, and we're right there on the river at the end of the block, and I'm not sure how that road is only, you can only turn onto Brant Lane one way, and I just don't see, if that road is being used for all of these apartments, how we would even be able to stay there with the traffic and everything. You can only get one car down that road at this time, and there's no way that that's wide enough with the river to make it two-way traffic.
Let me just address a few things you said. There's no access point to any future development or quarry from Brant Lane. The ordinance clearly states that the quarry expansion would not even occur until Tilcon had access from Wanacue on Union Ave. So that's where their access, if they ever get it, will be. Otherwise, it's status quo through Pompton Lakes. The development of 360 units, that's court-ordered since 2008, the access point for that is on Union Ave, right behind our DPW. It's always been the plan. That's not new. That's been the plan that's been the plan for 30 years. But anyway, since 2008 when it was court-ordered, so that's the access point to
That's the only access point.
only access point there. Your flooding issue is unrelated to the ordinance, but a letter from, FEMA remapped, so any letter you received would just be because of remapping after all the storms over the past few years. As far as rodents and property maintenance issues, you need to let me know, or you can contact me at Borough Hall, and I can have property maintenance inspect. I know the house you're talking about, that was vacant because the elderly couple passed, and we can deal with those kind of issues. But the primary answer to your question is there'll be no access to anything other than the animal shelter and the few homes on Brant Lane.
Okay, so you could assure that the development, you could tell me that development and the mining won't ever have anything to do with the Pequannock River coming any higher?
According to the studies that were provided to the governing body, there would be no impact to flooding as a result of a quarry expansion.
Okay, so if this passes, are you going to give me your word that that's not going to happen?
Could I have given you a word that 2 weeks ago we would have 8 inches of rain in a 200-year storm in 24 hours? So no, that would be impossible to do.
I'm saying other than a natural disaster, that this will not affect the runoff on Brant Lane, this development.
Based on the professionals, the borough engineer that represented that, that's what we're all basing that on. Can I assure anyone anything in the future from rain and river heights? No.
I'm just saying normal rain, not.
Your question was, can I guarantee you? No. What if Pompton Lakes didn't desnag and they had backups and you flooded more than normal? I mean, it's going to be the quarry's fault. There's so many variables, like 8 inches of rain in 24 hours, so.
Grant Lane has flooded for years.
Right.
I mean, I've been here for a long time, and that
Yeah.
kind of goes first. I
Yeah.
know exactly where you live. I've been down there, been in a boat down there, going back years ago.
Yeah.
Yeah, but that's,
It hasn't since we've been here.
yeah.
It was.
Okay.
But thank you. Yeah, do you have
Thanks.
anything else? Yeah, thank you. Anyone else, please? Yes, please.
Hi,
How are you?
Mark from Union Ave.
Yes.
You just mentioned something about Access Road, not on Grant Lane, but you just happened to say
Access
something.
road for the condo complex that's
Right.
been planned forever, has always been planned, which will be right behind DPW. You know where that paper road exists now, where you called me about the
Yeah, I
dirt
forgot
being
about
dumped
the
there?
trucking going
That
on.
is the plan.
That's going to be the road?
Mm-hmm.
It's across the street from me.
But that's been the plan forever.
So in other words, if the...
Not the quarry.
Quarry, or development.
That would be the access to the
Development,
32
yeah,
acres
development.
of the
So
development.
across the street from me, basically, you know where I live.
Yeah, sure.
I could have trucks going in and out of there if this happens.
Well, during the process of developing the site, no, because the plan has always also been the trucks for developing the site, with or without the quarry expansion, the plan has always been a haul road from the back of it to the quarry. So they would not be
Trucking right now.
trucking, you know, I mean, well, you have trucks, sure. I mean, like Avalon Bay, when that was built, you had trucks, but the majority of trucks has always been the plan. This is not new to what we're talking about today. It's always been the plan. Would be, like any rock removal for the development, would be taken on a haul road from that site to the existing quarry. That's always been the plan. So,
Boy.
but Dee, that's not new. I mean, if you were following the last 30 years of the fights for development on Mere,
Yeah.
okay, there was actually 2 entrances. There was supposed to be that one and one on Van Dam. And because the
Okay.
court order and the town and we got the development down to just 32 acres, that's where the one and only access point was decided in 2007 and 8. In a plan that's on the books forever.
That's just new to me, that's all. I just
Yeah,
went-
no, I'm surprised it's new to you, knowing how much you know what goes on, so.
Well, I'm only aware of it now because of the Ryerson, the road being built and the truck, you know, whatever
Right,
they talked
right.
about.
Mhm.
That is going to be the access road if this happens.
It's always been the plan.
A plan is one thing, but all of a sudden, every day I'm going to
Well,
have
it's always been the plan, that's my
20,
answer.
30, 40 dump trucks going.
Well, again, the bulk of any site work
Yes.
will be taken the back, so no, the answer is no, but, I mean, will there be trucks during the development of a complex? I'm sure, yeah,
Yeah.
sure.
Right across the street. That's
Again,
great.
Dee, that's pre us, that's a long time ago. Thank you.
Lori Weinbrock, 45 Highland Road. I'm really concerned about I-3 as well. Your response of duly noted, it kind of doesn't say anything, doesn't respond or give an answer or an opinion.
I think the borough attorney expressed the intention of those statements. There's absolutely, unequivocally, will be no access to a quarry from Van Dam or Union Ave other than in Wanacue. The quarry expansion does not even occur unless they get access from that one point.
Yes, but when I read it, it does, I don't know, maybe I don't understand English. The access to the property shall be permitted from an adjoining property if there is consent. It shall be permitted.
Right.
So what if someone who owns an adjoining property decides that they don't like living next to a quarry? Let me sell my property so they can have, for a really large amount of money, which the quarry might offer, and there will be a road.
But they could do that with or without an ordinance and go in front of the planning board for a site plan, a variance, to get such approval. As this states, if, to your point, if that was to ever occur, they wouldn't be able just to do it. They'd have to get approval. So you're saying if someone on Van Dam wanted to sell their house so the quarry can access it, yeah, they would have to get site plan approval. I can't
And they
imagine that
could,
occurring.
and they could.
Well,
Why can't we just say, you can't?
it would be a variance, right? But they could do that with or without the ordinance, is my point.
Why?
Well,
I mean,
because
if it's in the
anyone
ord-
could
if
try
it-
to vary from zoning to do such, anyone. I mean, you could try to go to the board and put a McDonald's on your house. You'd be denied, but you could try. That's the same thing.
But wouldn't it be more protection if 3 was not there and G was and said, no, it won't
No, we're not
happen?
making
Wouldn't that be more protection for us? We could point to it? Or doesn't this mean anything? Doesn't it mean anything that people can't use it in the future to say, look what we decided?
What do you think?
Section G says there's no access except from the adjoining property, the adjoining quarry. That's what G
Yes.
says. And when you read it with I, so that's, it has to be an adjoining quarry operation. And I says you have to have consent from the adjoining property owner. So that's, you know, they're read in tandem, and they're not conflicting. They supplement each other.
You keep
It has
saying
to
that,
be-
but-
Because that's
It's right
the
there.
answer.
That's what it says.
But right there, it says shall be permitted from an adjoining property. That says it as well.
Right, but you
Why
read
can't
both
we
sections.
give ourselves, the people of the town, better protection and not allow it, so that in the future, if someone wants to do that, we can say, look what we decided, it's in writing, or doesn't this mean anything?
Let me ask you.
It does mean something.
but-
It means exactly what
I know-
we've
you
said.
know that, I know.
And it's on the record here tonight. It's on the record. If anyone were to ever go back and look at the record and the intent of this ordinance, if there was any type of dispute, it's already been said. It's only for getting approval from the contiguous operation, not, as the mayor said, not from Van
It
Dam
doesn't
or
say,
any other
it doesn't
location.
say operation, it says adjoining property.
G says the adjoining quarry operation, except from the adjoining quarry operation.
There shall be no access provided with respects to the overlay zone except from an adjoining quarry operation and site. That's what it says.
But
Then
permitted from adjoining property. I don't know, do I not understand English?
It says adjoining quarry operation. No, Dan.
That's under development standards.
Right.
The other section is about setbacks and restrictions.
She's reading setbacks and restrictions.
Regardless of what this sentence says, anyone can sell to the quarry, right? But they can't, the quarry can't make it a right of way into Bloomingdale. They would have to come in for a whole planning board site approval, right? Anyone can sell to them, but they won't have the right to come into Bloomingdale, ever.
Why, if it says with,
Because they have to come in front of the planning board.
and why wouldn't the
Regardless
planning
of what
board
the-
approve it?
Listen, there is a law in place that you have to get a variance, right, to enter, to.
Yes, I understand, I know what
So
variances
regardless
are.
of this document, there is a law in place already. So this
What's
doesn't
the law that says they couldn't ask for a variance and the planning board couldn't approve it?
Look,
Okay,
they
Mrs.
can absolutely-
Mrs. Weinbach, again, the last thing I wanted to do was start making changes again, but I hear my attorney's opinion, but I hear your concern, okay? And I'm willing to make one simple correction, which will not result in re-advertising back to the planning board. This is not a material change. I will absolutely, under I, change it so it says, the access, here's what it currently says, the access to the property shall be permitted from an adjoining property, so as long as the contiguous property owner gives consent. That's what it says right now, okay? What we can do to alleviate your concerns on that topic is say, the access to the property shall be permitted from the adjoining quarry operation site. So it's not just any site, it's the quarry operation. So item I3 will state, the access to the property shall be permitted from the adjoining quarry operation site.
Thank you for your consideration.
Okay? It's material to the benefit, to clarify language. I have no problem. Fred, are we okay doing
Yes.
that?
Yep.
So that's what we will do.
Thank you very much.
Thank you, Lori. Anyone else, please? How are you?
Good evening, Mayor Dunleavy and Town Council. I represent my mother, Evelyn J. Rafferty of 101 Knowles Road.
Okay.
I believe Mr. D'Amato may be acquainted with my mother. We were next door neighbors. 4 years ago or so, Mayor, we were discussing the building of Avalon Bay. And you said that in building Avalon Bay, you would be in compliance with the Mount Laurel court order and possibly avoid having to develop the Muir Tract.
Never said that.
You
That is
did.
absolutely, unequivocally incorrect. That was never stated by me. Because the Muir Tract is a court order. Never said it.
Now, Town Council, you say that you are simply abiding by the Mount Laurel court order. However, in March of 2009, the then Town Council made a resolution to sign on to the Sustainable New Jersey Municipal Certification Program. This program is tied back to United Nations Agenda 21, which has as part of its core values sustainable development and affordable housing. I can direct you to various books that detail the plan to turn cities into suburbs. The sign behind you, the town seal, says Bloomingdale, an American small town. To pass this bill in any way and develop that tract with 100% affordable housing or any other type of affordable housing will betray that town seal. One of the reasons you stated was for the advocation of this development was that the town would benefit and lower property taxes. However, the town would also suffer in lower property values. The people who would be occupying these high-density buildings would be only of two kinds: the very wealthy with no children, and the not-so-wealthy with far more children who are not in any way up to grade level. Bloomingdale Schools, I can show you, is in no condition to take on even poorer students than they already have. Ah, here we go. I did a study of the New Jersey ask tests, which came before the Common Core Park tests. And Bloomingdale Schools in 2009 dropped some 30%. Their scores dropped some 30% due to the advocate of the Common Core program, the Common Core curriculum, which was in place at that time. Even though they're only doing the park tests now, Common Core was already in progress, lowering the academic standards, and Bloomingdale did abysmally. You might be interested to know that...
So what you're saying on the public record is we should never build affordable housing because it could impact our test scores in our schools?
Yes, sir. They are
I just wanted to
directly
clarify that's what you were stating on the
They're
public
directly
record.
tied to
Wow.
property values. That's why
Okay, I
people-
just wanted to clarify.
That's why suburban families choose towns if they can for the educational level of the schools and their ability to teach the children. Bloomingdale is not a wealthy town. It never was. Originally, it was a factory town. Nobody would expect Yale graduates, although we would hope we might get some. But it's been holding its own. You bring in affordable housing with poorer families whose students are not up to grade. They will never be up to grade with Common Core. You will certainly diminish the property values in this town, and you'll not get the tax ratables that you were hoping for, not from homeowners. This is a bad idea. It never should have been approved. My mother, also it should not have been approved on a conservation level. My mother was a former member of the Bloomingdale Conservation Committee, And the reason she chose to live in Bloomingdale was because the developer of that development did not clear-cut the land. He left the trees in place. When you take away the trees and you hold up the mountainside, you allow flooding. If you lower the mountain entirely, if you level the mountain entirely, there will be no place for the water in the Paquonic River to go but onto the floodplain. Well, I've said enough. That's all I have to say
Thank
about
you.
that. I would urge the town council not to approve this zoning of Tilcon and the zoning of this high-density affordable housing. You will change Bloomingdale from an American small town to an American small city with all the incumbent problems of crime, pollution, litter, and the lowering of educational standards if you do this. Now, from what I understand, the original plan is 50 years from now. I live in Pompton Lakes on the other side of Federal Hill, or what is left of Federal Hill. And for the last 3 years, I've listened to the blasting, I've listened to the sliding down of the mountain. It will not take Tilcon 50 years to destroy what's left of Federal Hill. And it'll only result in even more iron oxide pollution than has already occurred. Residents in my community of Sunny Gardens have wound up having their cars damaged by iron oxide pollution. I happen to have a red car, so you can't tell from my car, but the other residents had white cars, and you could see the red specks all over the cars. They had to have their cars repainted. That's what comes with blowing up a granite mountain to pave roads. And I think that's all I have to say now.
Thank you very much.
Thank you.
Anyone else wishing to speak? Yes.
Lenore Johnson.
Yep, just need to come up, then there's...
Yeah,
I'll
Lenore
get you
Johnson,
next.
83 Morse Lake Road. I just want to say, my concern is not with the quality of the people in the development or the quality of the children in the development, but the environment of Bloomingdale. So it's not about the people who would come, it's about the environment we would lose.
Helena Guy, 12 Ty Street. I just want to speak a little bit to accountability of this council. I've been coming for a while now, and I've listened to all of the experts speak. The last time we were here, one of the residents asked you all if anything that any of the experts said made any difference in your opinion and your vote. She asked if you took any of the environmental studies and the impact on our quality of life into consideration when you were deciding on your vote, and there was utter silence from you. In fact, you, Mr. Della Ripa, as I watched the tape back, threw up your hands without, I guess, having any idea of what to answer. And Mr. D'Amato, you went on to tell us that a lot of other people that you've spoken to here in town have indicated their support for this measure. So I'm wondering where those people are, because they must know after all this time that there's contention and there is, dissension regarding this idea. So where are they to support you and this council if they in fact do so? I would like to know who they are and what their credentials are, if that is what you are basing your vote on. Because you have said in the last vote, and now in the last meeting, and now we've had several of those people come up again and reiterate their positions to you, and yet it does not seem to make any impact. So I am wondering what the credentials are for the people that you are basing your opinion on. Mr. Kushner has indicated that some of the studies on our site are erroneous in some respects and misleading in others, and yet that's what a lot of people are basing, I'm sure, their decision about this on. because that is the only information they have, as they have not been here to these meetings. So it leaves me to wonder why we are still going forward in the face of all of this environmental impact and the quality of life concerns. It kind of brings us back to the question that Mrs. Shortman asked you the last time, Mr. Mayor. What's the deal? And I'm still wondering what the deal is, because you never answered that question for her. You kind of walked around it and danced around it and conferred with Mr. Semru, but you never really answered what the deal was. So I just want to remind you that you are public servants and that you are here to do what the public wants you to do, not to satisfy your own agenda. So I would just ask you to please remember that this evening.
Thank you. Anyone else, please? Yes.
Jennifer Allfield, 17 Cedar Street, Bloomingdale, New Jersey. Mr. Mayor and Council, I am here to support the Tilcon overlay and the building of affordable housing on the Mere Tract. With respect for the affordable housing, this is a court-ordered so that Bloomingdale complies with the COA housing requirements. Bloomingdale went through a long, arduous, expensive legal fight, costing our town's taxpayers millions of dollars, and which in the end we lost. Builders' remedy lawsuits are for the most part difficult to win, and the cost is unbearable for Bloomingdale taxpayers. Now there is a threat of another lawsuit by a certain group of residents that should you approve the Tilcon overlay, they will file a lawsuit. No one is permitted to stop a corporation from conducting business that the state and federal governments have approved and that Tilcon has conducted for numerous decades. With the implementation of an overlay, it will enable Bloomingdale and our future elected officials to have the ability to decide the most effective way to build out the site for businesses and thereby bring tax revenues into Bloomingdale. By putting businesses on the site, it will enable Bloomingdale's business customers access via the highway, the same way Riverdale, Butler, Kinnelon now enjoy. We don't have that. We're landlocked. We have no access to our stores, our shopping, our restaurants, because we have no direct access from the highways. Part of the responsibility of council members is to take into consideration what is the best for the entire municipality, now and in the future. The discussion of our councils, past and present, has been how to bring business into Bloomingdale. While this is not an immediate fix, it is the start, a starting point for businesses to be able to move into a site once it is completed by Tilcon. The threat of a lawsuit against Bloomingdale and the residents is not a responsible act on the part of a small number of residents. As a former council member of Bloomingdale, we have had issues of not moving forward with planning, but going in the opposite direction. It is now time for Bloomingdale to come together, make plans for moving this community forward. With a tax-saving move for all of our residents. Tilcon has been a good neighbor, and especially during severe weather storms where we have needed equipment to move out some of our residents to a safer area. I hope that you as council members will help bring our town forward with the approval of the Tilcon overlay. Thank you.
Thank you. Thank you. Anyone else wishing to speak? Seeing no one, a motion to close?
So moved.
All in favor?
Aye.
Okay, at this time, I need a motion for adoption of 2016. I have a motion from Councilman
That,
Yazdi.
Mayor, would be as amended with that one
As
change
amended with adding
to I3, the word
I3
quarry.
quarry site. Right. Thank you. Who seconds that, please?
Second.
Any discussion? Does anyone have anything to say?
I just wanted to say, because this has been very difficult for me, which is part of the reason I didn't really answer why you saw what you saw, is that from a personal and family background, I tend to agree that this is not what you would choose to do from an environmental standpoint. And were I not sitting in this chair here, I may be alongside you. But as a council member, I feel it's my obligation to do what's best for the borough. And that's why I'm going to vote the way I'm going to vote. It doesn't make me happy either way, because I think I'm choosing between the lesser of two evils. So I just, I wish there was another way, but we've talked about this for years, and no one has come up with another one. So that's all I wanted to say.
And just to add to that, I mean, when life hands you lemons, you make lemonade, okay? You try to do the right thing for your town. This isn't a proud vote. This isn't something that we want to throw in your face. A friend of mine I was talking to, he lives in Richfield, and they wanted to put a cell tower across from his street. So his entire street fought it. They went to planning boards, they went to town meetings. The town turned it down, okay? The state comes in and says, technology moves on, and approves it, okay? They didn't approve it the way the town wanted to get it done. They approved it the way Verizon was asking for it. This is exactly what would happen here if we don't move forward with this. Affordable housing is the state law, and it's nothing that we can turn around and say, because you're gonna have less fortunate kids, we're not gonna approve this. We have to do this, or the state's gonna step in. And that's why I'm gonna vote the way I'm gonna vote.
I'd like to add something to that as well. Obviously, I'm not voting, I'm voting on an affordable housing initiative. It came to my attention with a quarry overlay. I did not create that. But I feel at this point, the court with its mandate will not find it favorable on the town of Bloomingdale to avoid the affordable housing by voting against it. I heard your objections. I read the materials. We did our homework. I object to some of the outraged comments that we're idiots on the council. We are not idiots on the council. We went through a great deal of research and reading to come to our decisions. And I think the group has not always agreed on the decision we're going to make as individual council people here. And you have to respect that. Thank you.
Anyone else? Before roll call? I just like to state, obviously, we know our form of government is a borough form of government, and I only vote if there's a tie. So I'll make it clear that I do support this ordinance, and it is a very, very difficult decision for the governing body to make. No one is thrilled about the consideration of expanding a quarry in Bloomingdale. Nobody. The problem is, and also no one on this governing body created the issues that Bloomingdale faces. There's a court order housing that some in this room would say, so what, let it stay, it'll never be built, that's a great thing, okay? The problem is, you have a landowner, private landowner who owns 180 acres of Federal Hill, who easily could look to do a lot more than the 360 court-ordered units that are proposed currently on that site. The one thing the residents in this room are not speaking enough about is the affordable housing component of it. And we're not the only town, it's been stated here that I'm the only mayor who cares about affordable housing. There are more than 85% of the municipalities in New Jersey in front of Superior Court judges trying to resolve their affordable housing issues. As part of this ordinance, we were able to reduce our affordable housing obligation by 489 units. Okay, between the e-consult numbers that we represented we could achieve and the fair share housing numbers, we were able to receive a court order and reduce our numbers by 489 by doing what we can to enable this 360 unit development that again predates all of this governing body. People even tonight said, don't vote for this development. We're not voting for this development. This development predates all of us. We're voting for a way to enable it because that is our obligation. Because if we don't, we will continue Bloomingdale's history of not controlling our own destiny. And that is why we are in most of the predicament we're in on an affordable housing and a rateable issue and so on. So it's not an easy decision. And listening to the concerns, we did hire our professionals, and because everyone in this room, except for 2 people, I believe, who clapped for someone who supports it, don't agree with our professional reports, and I'll respect your opinion, but that's because you're against it. Everyone in this room agrees wholeheartedly with everything the Pequannock River Coalition states because you support that position, and I respect that too. But we did listen to your concerns, and that is why we will, the next step, assuming this passes, will be to reach out to Green Acres, negotiate with the Save the Federal Hill Committee, to look to utilize some of bicoastal, which is a landlocked, lake-locked piece of property on the outskirts of the borough, to do what we can to save all or as much as we can of the 140 acres remaining on Mere. That will be the next goal of this council. And someone may ask, well, why are you doing the zoning then? And I'll be frank, it gives the leverage to consider that next step. It absolutely does. And that's, I'm hoping we gain support to, when we go to Green Acres for this consideration, because our goal now would be to preserve what we can, the goal being all of it, of the 140 acres on Mere by giving up some of some other open space in town. But we have, for the first time since 2004, have subsidence certification, meaning that we're protected from being sued by future development. That is paramount. If we did not get a successful judgment in court, someone like Finbar, who now owns 180 acres of Mere, could do what Avalon Bay did, could do what D.R. Horton did, a joint venture with a developer, and say to a judge, because we're not protected, hey judge, we can build the 489 affordable housing units. And a judge, like they did in Bloomingdale's history, grant that order, and we haven't controlled our own destiny. And that is what we're doing. So at the end of the day, because all along I've said things and they've been thrown back. The mayor said it would be 20 acres. The mayor said our goal is to minimize the expansion, to maximize the return benefits on the affordable housing compliance within the borough. And again, step 2 is to do that. And that's what we will begin to do. The second item on tonight's agenda is the license fee ordinance amendment. Currently, the borough has a $15,000 licensing fee ordinance that annually Tilcon must pay. As a result of expanding hours, which we have, to some operations, like their maintenance shifts and some of their asphalt crushing shifts, we have expanded our hour of operations. But as a result, we're increasing that fee to $400,000, which is a direct impact benefit to the taxpayers. I'm telling you now, that is just one small step as we proceed with potential additional benefits. And some of you say, well, that's not worth $400,000, and I get it. And someone said our job is to listen to the residents. I get that more than most. The issue is we do, but the issue is we also have I said it once before. I said it's easy for someone, and I respected immensely your opinion on not supporting it, But that's all you have to concern yourself with, is this one issue and not supporting it. I have to concern myself with this issue, with affordable housing, with taxes, with how I'm paying the pension obligations, how I'm paying our failing infrastructure, and so on, without continually going back to the well of you, the taxpayers. You know, this 400,000, one minute part of a potential benefit in itself, and Ray and Rich on the Finance Committee can already attest that how this will help next year's budget. Like, we already know with that increased revenue that there's a good chance there won't be a municipal tax increase, or a minimal one. We do know, without new revenue, that you would see an average of $300 to $400 in annual municipal tax increases forevermore. And that's no joke, because my mantra's always been, expenses aren't our problem, revenue is, and that is certainly true. So I respect the environment issues. It's a difficult decision, but this is why now we will proceed to look at bi-coastal and save as much, if not all, of what we can on the mirror track. I want to remind everyone that nothing becomes effective until Mount Laurel's achieved. Mr. Hawkins raised, rightly so, I don't foresee this ever happening. And if that's the case, nor does the quarry expansion. But our goal is that this will enable the affordable housing. But if it doesn't, then Tilcon doesn't get the luxury of quarrying the expansion either. So that's an important part. So, again, contentious as it is, I would support it. And I would turn it over to any of the councilmen if anyone has any other comments to make.
I do. Prior to me sitting up on this dais, I sat where all of you sit. And I remember asking the council at the time, what is your plan? And do you know what their answer was? We have no plan. That was their exact answer. I believe that this council has a plan for the first time in a very long time. And I think the residents need to give it a shot. As I walked this town, and I've said this many times over and over, I walked this town when I ran for council. I heard over and over and over again the complaints. And the first was taxes, over and over and over again. I think that we have a plan of action, which I didn't see as I sat where you all sit. And I'm happy to be part of that plan. I know I'm not making everyone happy in this room. You don't need to tell me that. I know I don't make some of the council that are sitting up here today happy. We will agree to disagree, and we will walk away as a group knowing that each of us made the decision that we feel is best for this town, as Tony said. I've listened, and regardless of also what people may think, I have listened to every single person that has come up here. So I can walk away also knowing that I have listened and that I'm comfortable with the decision that I'm making. Mayor?
Anyone else?
Yeah. Came up here before and said the people I've talked to. I have talked to people regarding, and some people negative against it. All right. But when I talk to other people that are positive, you ask why they're not here. And my feeling is they have faith in what we're doing. And the decisions that have been made in other projects that we've been on, mostly with John, with all the stuff that's going on in town, that we're doing, I'll say a decent job. I wouldn't even say a great job. Okay, we're doing a decent job of moving the town forward. Some people will come up here and make Tilcon the big bad wolf. Okay? I've personally experienced what Tilcon does for the community. And I'll give you an example. We had railroad ties the other day in Bloomingdale across the river.
a huge stretch of piled railroad ties catch fire. Okay? In the middle of the night. Now, you people don't see this because you're home sleeping. We get called out along with Pompey Lakes Fire Department. We're out there. All right? And it was really going. And we think it started from a train going by and throwing sparks because things were dry. Tilcon sent a huge bucket loader over and moved all those railroad ties so we can get into it so it wouldn't travel up the hill. All right? We didn't ask them to. They came and they did it. Pompton Lakes has flooding issues, or 287 was washed out. Tilcon does a lot of things for the community. And that's not my only reason. I listened going back when we first started this. I think it was your wife that came over and said about the environmental and the dust and all that flying. For 30 miles, 2 miles to 30 miles. All right? That's true. But the wind's blowing the other way, it goes to New York. The wind's blowing this way, it goes up front. But we have an existing quarry that's going to be there anyway with the dust and the blasting. It's going to be there. If that quarry wasn't there, I don't think we'd be having this conversation at all.
No.
Because it's not really the best plan in the long run. It's going to work for us, but it's the only plan we have to get us where we need to be as far as I'm concerned. And I understand you live down there. I understand all that in your backyard. You don't want it there. I don't blame you for that. All right? I understand all that. But it's all right if we move it to somewhere else. Okay? Which would be the best plan. If we can work this all out, would probably be the best plan for everyone. And we're going to work hard. And to be honest with John, Ray, and Fred are going to jump into this thing. And Fred already said, the plan is to start working on that part of it. All right? Will it happen? We can't guarantee it. It's a negotiation, as you guys all call it. Okay? Like I said, it's not the best plan, but it's a plan. And that's why I support it.
Okay.
Fred, before we go into it, I know the mayor mentioned
I know Mike.
400,000 and all that. I just want to clarify that the $400,000 fee has nothing to do with this ordinance. This is an affordable housing overlay ordinance on its own. Just clarify.
Right. It won't apply unless there's quarrying on this, but it does apply to the existing site. Correct. Due to the fact that you're permitted to license and collect a fee.
Right.
So that's a separate thing.
Right.
It has nothing to do with it.
Right.
I understand that.
Right.
But it's
This could get turned down and that could move forward.
correct.
That's right. That's correct.
Two separate issues.
That's right.
Correct.
Right.
But again, a lot of no. And I want to, and I thank you for clarifying that. My point on that one is, it is the overlay that talked about extended hours, which tonight we're going to do on the existing. So, if we weren't talking about the overlay in extended hours, chances are we may not be on the M1Q either. So,
No, it's
there's a financial benefit.
destiny, getting the 300-foot buffer, getting the hours of operations that our planning board is demanding, rather than the state coming in and saying, this is what you're doing, because that's what they asked for. This is the right way.
Right. And more importantly, achieving affordable housing, builder's remedy protection, and so on. Councilman Sandemeyer?
Yeah. Although I think the ordinance is written very strongly to protect the residents of Bloomingdale, and I applaud the efforts of the planning board in that as well. I still think the cons outweigh the pros, and not having a referendum to voice the public's opinion on it and to sway mine, I believe with the people that have shown up here over the last 3 years and the people I have spoken to on the streets of Bloomingdale, I believe I speak for the majority of Bloomingdale when I vote no tonight to this overlay.
Okay, thank you. Okay, Madam Clerk, roll call, please.
Councilmembers Costa.
Yes.
D'Amato.
Yes.
Della Ripa.
Yes.
Hudson.
Yes.
Sandemeyer.
No.
Yazdi.
Okay, item B, need a motion introduction ordinance amending M1Q zone by title. Who makes that motion?
So moved.
Second.
All in favor?
Aye.
21-2006. It's 20th. Second and final reading, September 20th, because this has to go to the planning board. That's fine, please.
An ordinance of the Borough of Bloomingdale, County of Passaic, State of New Jersey, to amend section 92-25 of the Borough Code entitled Excavations and Extractive Industries.
Thank you. Item C, I'm sorry, good. is, I need a motion to introduce ordinance 22, 2016, quarry license fee by title. Who makes that motion, please?
Second.
All in favor?
Aye.
An ordinance to amend Chapter 4 entitled General Licensing, creating Section 4-1721 entitled Quarry Licensing.
Thank you. Second and final reading also September 20th. Okay, at this time, I need a motion for late public comment. Oh, you know, I apologize. I meant to give public comment opportunity on those, but they can do that now.
So moved.
It's just by title. Thank you, Councilman.
Second.
All in favor?
Aye.
Anyone wishing to speak?
Anything?
Well, special meeting.
Oh,
It is about anything, but the governing body is limited to speak only about the items on the agenda.
Okay.
You can speak freely. yeah.
So we can't answer?
Well, you can, but you can't say, well, now we're going to defer this to a subcommittee or whatever. You can only just try to respond.
Linda Shortman, 2 West Shore Road. This letter was written August 3rd, and it is to the Bloomingdale Police Department, the Mayor, Council, and all the citizens of Bloomingdale. And it was a unanimous vote from the Bloomingdale Senior Advisory Board. And the subject matter is the police department. At the last meeting of the Bloomingdale Senior Advisory Board, the conversation came around to our town. Members began expressing their unanimous appreciation and gratitude to be living in a town where they feel so safe. No small accomplishments in the world today. Stories followed of the helpful, caring experiences with the Bloomingdale Police Department. It's time we let you know that you are appreciated and to say thank you, Chief Burrell, and all the members of the Bloomingdale Police Department. Whether you're a mom with a toddler or a senior living alone, we always know you will be there. On behalf of the Senior Advisory.
Very nice. Thank you very much. Anyone else? Yeah, okay. Hey, Jack, how are you?
Miller, Revav.
Long time.
Bloomingdale. It's been a while.
Yes, sir.
And there's been reasons why I've been away. And this is probably why I've been away. But with that said, I had a feeling this was going to go this way. And as the flood chair, I'm going to be on top of the planning board, and I'm going to be on top of you guys for everything that goes on over this overlay. Because anything that's going to damage and hurt these people that are in the flats is going to be a problem, okay? So as the chairman and as a resident, I will be here and I will take care of what I need to take care of. And you all will take care of what you need to take care of.
As we all should.
thank you.
As you should, as should we. Thank you. Anyone else? Seeing no one, motion to close?
So moved.
Second?
All in favor?
Aye.
Motion to adjourn? All in favor?
Aye.
Regular meeting Tuesday,